6, advisory opinions. Okay. We'll of course move to file 2773 and Ms. Planky, you are, is here as the requester here. Would you state your name for the record?
Allison Rogers, Escambia County Attorney.
Speaking very good question.
Thank you for coming. Ms. Planky, your
Commissioner, the issues before you today is one which arises infrequently in our analysis with regard to the application of the ethics laws, and which focuses on your interpretation of section 112.313, subsection 5. This provision expressly modifies the application of the voting conflict section contained in section 112.3143 to allow for a collegial body member who would otherwise have a voting conflict to vote on matters affecting their own, quote, salary, expenses, or other compensation as public officers, end quote. The purpose of this provision is to negate the gridlock which paralyzes collegial bodies, which are the only entity authorized to make decisions and vote regarding matters setting or affecting their own salary, expenses, and compensation. But the task of determining what is meant by that term, salary, expenses, or other compensation as public officers, is a job of the Commission on Ethics. And a careful, exhaustive review of the doctrinal history indicates that it is always a challenging one, especially in the context of the facts such as we have before us today. The draft opinion arose from an inquiry made on behalf of the Escambia County Attorney and on behalf of a member of the Escambia County Commission. For many years, the county has maintained by county ordinance a 401A local government annuity program for eligible elected county officers and senior management level county employees who have withdrawn from the Florida Retirement System, or FRS, in favor of this option. In the past 8 years, this local annuity option has become far more advantageous for people who have elected this option because the percentage of the employer contribution actually deposited on behalf of participants in FRS programs is significantly less than those deposited in the 401A plans. A review of footnote 4 in your draft analysis gives some particularities with regard to that. However, until very recently, the county's HR department did not inform incoming county commissioners or eligible senior management level county staff of the 401A program or the benefits of this option. And as a result, even though it has existed since the 1980s, only one county commissioner and very few SMS county employees have elected to participate in this option. As a result of this lack of notice at the time that the requester learned of this option during his second term in office, and he attempted to avail himself of the program, he was foreclosed from doing so. As elected public officers must decide to withdraw from FRS by law within 6 months after assuming their public office. When he was subsequently re-elected to a third term, he immediately withdrew from FRS and enrolled in the 401A program. In order to address the issue caused by the lack of notice provided by the county's HR department regarding the program, the requester would like to propose offering a retirement compensation resolution to the class of eligible elected county officers and SMS county employees that would be calculated based upon the difference between the employer's previous contributions to the FRS program and what the employer's contribution would have been had the person elected to participate in the 401A program at the earliest point in which they qualified. The county attorney's office has identified 16 individuals, including 4 out of the 5 county commissioners currently serving on the board, as eligible for the proposed retirement compensation resolution. And therein lies the issue. As you know, the voting conflicts law contained in section 112.313, prohibits in part a public officer from voting on any measure which would inure to their own special private gain. And in the instant matter, it is clear that absent the application of section 112.3135, the requester, as well as the 3 other members of the county commission, who are members of the eligible class, would be presented with a voting conflict regarding the retirement compensation resolution, for which they are eligible, which they would be eligible, because it would inure to their special private gain. However, the commission has previously found in advisory opinions that section 112.3135, which affects the application in the first sentence of the voting conflicts law, expressly permits public officers to vote on matters affecting their own public salary, expenses, or other compensation when such a benefit is derived from their position as a public officer. For example, we have applied this provision in previous advisory opinions to allow members of collegial bodies to vote on the public repayment of their own legal fees and expenses incurred while defending themselves against ethics complaints. We've also held that they can seek and vote on the reimbursement of their own travel expenses incurred in their public capacity, and the inclusion of themselves and their families in a discount on the cost of medical services provided by their own agency, a hospital district. However, the facts before you in the incident analysis require you to determine if the retirement compensation resolution itself constitutes other compensation as a public officer, such that 112.3135 should apply to negate the voting conflict and permit the requester and the other affected members of the board to vote on the matter. Or alternatively, if this resolution does not constitute such compensation in their public capacity, and thus the exception contained in 112.3135 is inapplicable. In such an instance, they would be faced with a voting conflict, one which would be largely preclusive, given the fact that 90% of the board would be so inflicted, or so positive. Because the retirement benefits at issue arise solely from the individual's public service as an elected public officer or an SMS class employee, as provided by law and via their own local ordinance, which creates the program, and because the proposed resolution is derived exclusively from public funds to address the inequality resulting from a lack of notice created by the county's own HR department, the draft before you proffers that the retirement resolution would constitute other compensation derived by virtue of their public positions, and thus the provisions of 112.3135 would apply to negate the voting conflict. And the requester and the other members of the board who would be eligible members of the class would not be prohibited from voting on the matter. The opinion then goes on to say that such a vote would not constitute a misuse of the requester's public position under section 112.313 subsection 6, or a prohibited disproportionate benefit under Article 2, Section 8 of the Florida Constitution, as the vote would not be inconsistent with the proper performance of their public duties while serving on the county commission, nor would such a vote be done with a corrupt or wrongful intent required for the application of those respective provisions. But here, I would like to turn your attention to page 10 of the draft before you contained in question 2. And in it, I would like to proffer for your consideration, should this matter go forward, in the first full sentence on page 10 of the draft, I quote, or I largely lifted a statement that was made in an opinion that CEO 91-62. It is as follows. In particular, we find that a vote on a resolution which is consistent with the application of section 112.313 subsection 5 of the Florida statutes cannot be said to be inconsistent with the proper performance of a public officer's public duties. Should this go forward, I would like you to consider my oral modification to soften that language. At the time that this was adopted, the last sentence of 112.3135, which is not an issue here, was not yet adopted within the statute. But we have, since the articulation that is contained here, which is accurate, should be further nuanced. And I would like to proffer that after the Florida statutes, citation, section 112.3135 Florida statutes, comma, a clause be added to say, and in the absence of facts which indicate the presence of a corrupt or wrongful intent, it cannot be said, and then the rest of that sentence. This is, or something of that ilk, or the authority to modify it in accordance with this instruction. Because we have seen since this 1991 opinion that there are instances where a facial 112.3135 argument may be pled and be applicable. However, in the presence of a surfeit of existing analysis and facts that indicate a wrongful intent, which we've seen in several complaints since the issuance of this opinion, we don't want to foreclose the possibility of scrutinizing them under 112.313 subsection 6, the misuse of public office, or a disproportionate benefit analysis under the new constitutional amendment, which became effective in 2020. However, none of those facts are present here. The requester is, we have asked a series of requests for additional information. They've been very forthcoming and candid, and there's no indication that such facts would occur. But for the future, we just want to make sure that we would not be foreclosed should those facts come before you in a complaint. Staff is available to answer any questions you may have. And the requester and the Escambia County Attorney are here with us and would like an opportunity to address you.
My staff can you, and are there any questions for Ms. Clanky?
Quick question.
Yes.
Madam Chair, in your suggestion as to the, what you call a verbal softening, by the imposition of the corrupt or wrongful intent phrase, are you imposing a higher or new standard that needs to be imposed, given the constitutional amendment that speaks to disproportionate effect?
I use those terms because the intent component that is defined within our rule 34-18.001, which this commission adopted, defining in part the intent requirement, adopts some of that language. And the purpose of this addition is not to impose a higher standard, but it is to continue to recognize, as we have previously, that a 112.313 argument wherein an individual, and I have a illustrative example that I contemplated in suggesting that perhaps a softening was necessary. It involved the last sentence of 112.313.5 that is not implicated here, but involves and allows for people acting as governmental attorneys to consider matters affecting their own salary. We have had misuse of public office investigations based on complaints wherein they did erroneously inflate their own salary when at the time that administrative personnel that had an economic check on their ability to unilaterally increase their own salaries retired. And they did so quite a bit.
Madam Chair, I apologize. Let me try to put a finer point on my question to save time. The whole point of Amendment 12 was to no longer require a corrupt or wrongful intent, but rather to utilize the term disproportionate benefit. By imposing corrupt or wrongful intent in your phraseology here, do you not revert to the higher standard that the constitutional amendment was specifically designed to lower in order to find that there's been an ethical violation?
That was not the intention.
Could it be the effect?
It is, there are several factors we would consider in analyzing pursuant to the rule provisions that would define disproportionate benefit. we would contemplate. There's a mens rea component we would also scrutinize. If you would prefer, my design is only to make sure that in the presence of a 3135 argument, we are not foreclosed from looking at them under the disproportionate benefit constitutional amendment or the misuse of public office.
Thank you, Madam Chair.
Can I clarify, when the term softening of the opinion really is actually tightening the ethics requirements and ensuring this opinion rejects any, even if it's done with corrupt intent, you can't deny it, correct? So the word softening is kind of misleading. This makes this opinion less, or it limits these actions further rather than granting greater latitude if you amend it the way you wish.
Correct. It would not be to the deficit of this agency's ability to scrutinize behavior or conduct that is implicative of disproportionate benefit or misuse of public office, even when the person has a facial argument for the application of 3135.
Thank you, Madam Chair, that helps.
Thank you. Commissioner Walton.
Thank you, Madam Chair. Would your opinion or position be the same if the class was smaller? Because here you have a class, essentially 25% of the class are the elected, are the members voting on that.
The analysis under whether or not the section 112.3135 applies would be the same. The class size is, as long as it is finite. However, it is not dispositive regarding whether or not the exception contained in 112.3135 is applicable. 112.3135 applies to expressly permit and negate voting conflicts to allow members of collegial bodies to vote on matters affecting their own salary, expenses, or compensation.
So, Madam Chair, to follow.
Yes.
So it wouldn't make it, if you're saying that the only 4 people who were affected were the 4 people voting on it, that's still okay?
Yes, and they would still be faced with the same analysis because the analysis focuses on the individuals who are on the collegial body. They are the ones who only have the 112.3143 voting conflicts provisions applicable to them.
And so, Madam Chair, if the proposal were to give the chairman of the Board of County Commissioners a $25,000 in-service education allowance to spend at his discretion, and the use of a $50,000 vehicle to drive, and it was only a class of 1 to benefit, under your analysis, it would be proper for him to vote on that.
Under my analysis, we would have to look at those particular facts. But in the past, I mentioned the express ones, the advisory opinions that have looked at what could compensation be. But for example, we've looked at this in terms of a town council member permitting him by virtue of the application of 112.3135 to vote on his own appointment. And the city mayor to vote on the budget, which establishes a higher salary for himself. That's why I mentioned that these are all tough questions because of the exact question that you raised. It can lead to a parade of horribles when this agency doesn't carefully police the boundaries of it. But that is what we have to do as the Commission on Ethics.
So, Madam Chair, notwithstanding the caution that you just expressed, you would still answer the question, yes, the county commission chairman could vote on a proposal to give himself $25,000 in education expenses to spend at his discretion and a $50,000 car to drive, even if he were the only one to benefit.
Would he be permitted under 112.3135, which expressly allows any public officer to vote on a matter affecting his or her own salary, expenses, or other compensation as a public officer? Yes.
And in your view, the constitutional amendment prohibiting disproportionate benefit to himself or his relatives or his business associates would not trump that?
No, not in the instant case, because in comparison to other members of the class of 16 affected individuals, for which the formula is uniformly applied to determine the benefit that they will in fact engender, if this is approved, then he is similarly situated and is
But
not.
what is not hypothetical? A class of one.
Would he have a voting conflict that would require his abstention in light of the application of 3135, which expressly allows him to do this? No.
And so therefore, the fact that he is voting on a proposal that gives him clearly a disproportionate benefit, himself solely and only, in your mind, the Constitution sort of knocked him among friends?
That would be a careful scrutiny we would apply under this new provision, which has only been effective since December 30th, 2020. We would have to parse those facts with particularity. I can tell you in this matter that there is no indication of a disproportionate benefit or the intent requirement, as it is not inconsistent with the proper performance of their public duties to deliberate these types of resolutions for equity.
Thank you, Madam Chair.
Chris, I wanted to be recognized.
Thank you, through the chair. This goes somewhat to what you were asking, Commissioner Gates, if I can follow up a little bit there. I think what Ms. Clanky is attempting to do with the word softening really, I think, is really a hardening. And it's a desire here to not preclude the commission from finding differently on a different set of facts that are more egregious than what is before you.
That was my point.
And these advisory opinions are, the reason this is coming before you is it's a particular set of facts that you need to look at, and it won't legitimize any parade of horribles in the future. And people in the future, if they do abuse their position to get something weird and wild, like some of the things that you mentioned there are just very self-ingratiating and very abusive and very insular and very disproportionate, that's a far different reality than what these folks have put in front of us here in good faith today on this. And this is a really more of a regular benefit type thing of a position. And what she's trying to do, changes a little bit of that sentence, is to leave the door open to get the really bad actors in the future, or to deny a request if somebody comes with an opinion in the future and it obviously is disproportionate and abusive. But it would not appear that that's the case with this one, but she's designed to keep the door open individually for future abusers. And the Constitution is very much going to be a part of that, along with the existing statute that's already been there. They're both not shut by what she's proposing. The door is open to get the abusers in the future. Thank you.
Are there any other questions for Ms. Clancy? Would we want to hear from the requester now?
Thank you. Thank you. Good afternoon, Chairman, members of the commission. I appreciate the opportunity to be here. Certainly support the recommendation that came from staff, and I would ask that you do likewise. And I certainly appreciate the opportunity to come before you before ever taking any issue up with my agency or my board, to try to get in front of it, to find out an opinion from you before ever having to come before you. So, thank you, and I am here to answer your questions I can as well as I can. Not an attorney is here as well. There's some of the communications that she's having with staff that I may not be privy to. Some of the answers I may not know that she may know, some institutional knowledge that I might not have.
Are there questions of the requester? Must be none. Thank you. Is there discussion on the draft opinion? No discussion. Is there a motion, discussion? Commissioner Gates?
Thank you, Madam Chair, and I move to adopt the draft opinion.
All right, is there a second?
Second.
Second, we have multiple seconds. All in favor of Commissioner Ankers?
I just want to have a clarification about the hardening of the language. Is that included as a part of the motion?
So of course,
He says yes.
I'll always defer to Commissioner.
I'm deferring to Attorney Blanket.
Yeah, and given that toughens the standard, that's our understanding, correct? Very good. All in favor of the motion signify by saying aye.
Aye.
Any opposed? Show the motion is approved. Congratulations and good luck.
Thank you very much.
Next we'll go